You've been sued. Now what? Right? So that's the topic today on Spot the Issues. The Campbell Firm PLLC is a general practice law firm. This is not direct legal advice. Of course, you should consult with your own attorney. If you don't have an attorney or you'd like to have a second opinion, obviously you can contact the firm for a courtesy consultation. Be happy to speak with you at an appropriate time. But there's no attorney-client relationship simply by watching this video. So you've been sued. Now what? Well, you need to call a lawyer. You need to take very seriously the lawsuit, the papers that have been served upon you. It cannot be that you ignore them. You'll ignore them to your peril. There's such a thing as a default judgment. One of the things that people don't realize is there's usually, differing times depending on the type of service that was provided. If they drop it off and hand it to you in your hand versus they serve if they're a corporation through the Secretary of State or there is some other form of process. You have different time periods that are required to respond. And a lot of times people think, well, if I wait till the last minute, maybe it'll cost me less. I can get attorney to kind of throw papers together and I'll be able to get it done more cost effectively that way. Well, actually, that's not generally true. And often you can't even get a lawyer to touch it if it's too close to a deadline, especially if you've got an opposing party that doesn't want to grant an extension without you having to go to court to make a motion to get an extension of time. So why would you sit and wait on it? And just don't do it. So when you get sued, one of the things that you immediately have to do is to preserve every document, every piece of evidence, every photograph, every email, every voicemail message, anything that you have that relates to this matter, even remotely. You got to preserve it. You must make sure that you notify all the employees in your company not to start deleting things from their cell phones, deleting things from the server, not to be deleting emails and scrapping things that would cover up something. I think we can all remember the Enron situation with people, destroying evidence and all of the chaos that ensued from that. And there are penalties, of course. Now you're thinking, well, how would anyone know? Well, just trust me, that's not, there's always some copy floating out there and then it gets admitted at the last minute. And even if not, the thing that you often think won't help you could be the thing that could help you and so forth. So, in any event, so you want to gather, all of your information. You also want to start strategizing with the attorney really early on to try to see, is the matter resolvable? Is it resolvable prior to filing an answer to the complaint? Or a motion to dismiss if that's an appropriate activity. Things that you'll discuss with your counsel. If so, perhaps an extension of time can be gained, between, so the parties can have an opportunity to try to resolve it. Sometimes it's just the thing that happens that at the last minute that pushes a settlement over the edge. If people have been trying to negotiate a settlement, for example, before a filing is made, and they just can't get to it. And then, of course, someone then files as a means to, to push the parties toward a resolution. But setting aside the settlement, you're going to strategize about the way in which the case is going to be handled and try to get an understanding of the costs involved, the different types of strategies that can be employed, and understanding that there's no right answer. It's a strategy. No one can know what the outcome. Nobody can guarantee an outcome. Now, of course, if you have no defense at all to, like, for example, a breach of contract case, like you didn't make the final payment but you took all of the services, and there's literally no defense because you say, no, I was totally satisfied with the services. Nothing was faulty. There was no problem, but I just didn't want to feel like making the payment. You're probably, not going to win. And then the idea that theoretically you should, well, I just want to pay less, so I'm going to offer them pennies on the dollar. Well, again, it will depend on the situation, but that's understanding that if you are, not operating in good faith, you may, even though normally punitive damages don't apply in a breach of contract case, for example, if there's fraud or something else, like you took services or products and you didn't pay and you sort of were defrauding, that's a possibility. You can get punitive damages out of that. So just be aware, that you also, it depends on whether the contract involved said who pays for attorney's fees. If the prevailing party is able to get attorney's fees from the party that loses, then you often can wind up not only paying for your own counsel, but paying for the other side, even if you even if you think, well, there's no real money damages here. So you have to really think through what is the goal and possible outcome, and then help proceed with a series of, I need to think through what I will do to better my chances with this case, if I'm going to be pursuing it as a litigation matter, and to get those type of strategies in place. So then, of course, as you're proceeding along, there's going to be issues and decisions that have to be made. You're going to have to be available for a deposition, which is, basically where there's a court reporter and they're transcribing things, and they're taking testimony just as if you were, sworn in a courtroom. In fact, if you're not available at trial, if God forbid you passed away, for example, or you're very sick, or some other reason that you're unavailable to testify, or that the parties would stipulate to using your testimony for some for whatever reason that there might be, what's done at that deposition is going to be critical, because that deposition testimony may become the foundation of the testimony that would go forward at trial. It certainly would become the basis potentially for any summary judgment motion, if anyone is made after the close of discovery, where one or more of the parties says, hey, I think I can win, and I win on the law, and here's why, and there's no dispute as to these facts, and I can show you through this testimony there's no dispute that you took the services and you just didn't pay. And again, any type of a claim, whatever it is, whether it's a securities fraud claim, whether it's breach of contract claim, whether it's employment disputes, any type of claims or disputes that wind up in litigation, will have this type of analysis, thinking through this. So if a company then is got to prepare and understand and inform the employees that even if they speak to the lawyer for the company, that the lawyer for the company, of course, the lawyer should be explaining, and the company probably should be doing this as well, that the lawyer represents the company, does not represent those employees. Most often, there's no particular reason that employees individually should be given lawyers, but employees will have to be produced on behalf of a corporation to testify about whatever matters. Sometimes it's the top level people, sometimes it's people who are involved in particular transactions, sometimes it's more than one party, but it would be the corporation will get a deposition notice from the opposing party that will state, for them to produce the person or persons that are most relevant and can give the most relevant testimony on the issues. So as the case will proceed, parallel tracking the settlement discussions would be certainly something that would be valuable. And depending on, once you gather enough information about the opposing party's case and evaluate the strengths and weaknesses of that case, you should be continuing to check in with your attorney. The attorney should be able to give you status reports, should be able to give you information that you can also provide to your investors as to the status. Sometimes you have to provide that information to your lenders, such as if you have a credit line, or are applying for a credit line, and they ask things like, is there any litigation pending? Well, yes, then the issue will be, what is the nature of it? So you got to be able to have an open line of communication with your attorneys to be able to say, hey, give me that series of sound bites, that little paragraph that I can drop into my update to my investors, update to my lenders, so that I can inform them properly as to what is happening, especially if you're continuing to raise capital. Let's say you're You need to raise additional capital with private equity, and of course you're going to have to make a disclosure about it. So one of the things that people fail to remember is, like, just because you believe that you may win does not mean that you will win, and it is certainly important for you to give a reasoned description of what the case is about, and and not to put only a one-sided, absolutely we're going to win, we're going to defeat them. It can't become like a political piece of propaganda. It has to be a reasonable disclosure, and so you should work with the counsel that you have to create that, and even if that litigation specialist needs to give that over to your corporate attorney to explain to again, to investors or lenders or to whomever it may be that needs to have that disclosure. As the case proceeds, again, the parallel tracking of the settlement negotiations. As you see, you have more bargaining power, they have more bargaining power. It's something that should be conceptualized, considered. And what I always recommend to people is to keep in mind that as the case proceeds, it becomes more and more expensive, and as you get closer and closer to an actual trial, which may take a few days to weeks or months, depending on the complexity of it, with multiple people involved, it's not just the court time that's costing money. It's the all the prep time, everything that's happening. And it's not just the 2 or 3 hours in the deposition, or the 2 or 3 days in the deposition, or sometimes a week if for a really important witness, or maybe longer, depending again on how many parties and how many people have to question the person at the deposition. But practically, again, it's not just that time, it's all the prep time leading up to it. It becomes a very expensive action to decide that you're going to actively be involved in. Now, unfortunately, when you're sued, you don't always get to decide that you're going to be involved in litigation. Sometimes the other party has decided it for you, and you don't have a way of even resolving it, depending upon what it is. And even a reasonable settlement may wind up initially falling on deaf ears, as they believe that if they have a really great case, they will get leverage in that, and they may not want to resolve it with sort of your view of a reasonable settlement. So there's some mechanisms in the court system to sort of deal with that, and with offers that are made and things like that. But it is as a practical matter, you have to sort of be prepared, and one of the best ways to do that is to continuously have an update. I would say that insurance counsel is probably one of the I give them an A+ when I have representing companies and we have matters that are being handled by insurance counsel. As outside litigators, they provide quarterly, status reports, and then they provide additional status reports after something significant happens. And I have to applaud them. They're usually very detailed and very helpful in evaluating what is going on in the case. And then, of course, again, read a report or get on a phone call, find out what's going on, and keep apprised of it, because it's going to make a big difference in how you make decisions about the strategy. And if you need to authorize them to hire a private investigator, or you need to authorize a forensic accountant, or you need to authorize different things, you may want to do that early on as opposed to waiting. Sometimes the wait and see approach of, well, maybe I don't want to have to incur that cost unless I absolutely have to. Sometimes being proactive is going to be a better bet for you than to just sort of take a completely defensive posture. So these are thoughts and about the process. I would say that procedurally, summary judgment is where you're going to wind up. Many cases will it's possible will not survive summary judgment. You see a lot of cases booted out on summary judgment. They don't get to trial, and then you wind up in an appellate process on that issue. But for the cases that do go to trial, then you need to have counsel that's really prepared to try a case. And I would say the number of cases someone tries does not have anything to do with whether they're ready to try a case. is a practical matter. It's stylistic. There are people who um, often try with the proportion of cases that anybody tries, unless they're on trial all the time, most of their cases are going to settle. And practically, that means that you really have to understand that the experience someone has to do with their, how many cases that they have, prepared for trial, how many depositions they've done. There's a lot of other factors that go into it, but the most important thing, in my personal opinion, is someone's willingness to try the case. You get a sense that there are attorneys that don't want to try cases, and you don't want your attorney certainly to give that message to the other side that they're afraid to try the case, or there's some reticence. Certainly the economic reality is it would be better to settle the case, but it cannot be that you basically retain someone who's not willing to try a case simply because you absolutely want to settle it. You should make your desires known to the lawyer as to what your goal is. If your goal is, I'm going to fight this to the death, obviously the person's got to be ready to go to trial. But even if we've got to get it settled, I can't afford all this stuff, that person still needs to be ready to go to trial, because you can't be sure the other party will settle. And it's important to put the sort of put it out there that you're not afraid to go to trial. And the only way to do that is to put forward somebody who is willing to do that. And I can say to you that there are plenty of people litigating today that you wonder, are they willing to do this, and why are they willing to roll up their sleeves and actually try the case? And the answer has to be, the person that you've retained to represent you when you get the notice that, hey, I've been sued, and you're going to get something called a summons, or a summons with notice, or a summons and complaint. And those all have different procedural things that have to be dealt with it. If you get a summons and then a complaint follows, summons and complaint, you get a summons with notice, you get all kinds of, it depends on what jurisdiction you're in, whether you're in federal court or state court, and what state you're in, if you're in state court, it'd be different procedures. But call a lawyer. Call a lawyer who's going to work really hard to make sure that your rights and your responsibilities are explained to you, and that you can make informed choices along the way, because there'll be a lot of decisions that have to be made. I thank you so much for tuning in to this episode of Spot the Issues. I encourage you to pick up the phone, call your attorney the minute you get served with a lawsuit, and to not be afraid. That's what the lawyer is there to do, just to help you and to handle it. So put it in good hands with somebody, and then continue to find out what's going on and to be involved. Litigation is something that people certainly would prefer that they didn't have happening most of the time, especially if they're served by another party. But it often can result in a positive outcome through settlement, and or through a decision at trial that is in your favor. But in any event, it's a necessary process, and any business should be prepared and especially if they've never been sued, they should always know that there's a first time for everything, and to be aware that litigation is something that can happen, and if it does, that you need to call an attorney. Again, thank you so much for tuning in, and we look forward to seeing you on the next episode.